Hi, I'm criminal defense attorney Aaron J. Boria, and today I'm going to be talking to you about the Michigan court procedure as it relates to criminal charges. If you've been charged with a criminal offense, then the first hearing that you're going to go to at the court will be for an arraignment. At an arraignment, the judge or magistrate will formally tell you what the charges are that you're facing and what the maximum possible penalties are. The next issue to address at arraignment is bond. The judge or magistrate will set bond based on a determination as to whether or not you are a flight risk and as to whether or not you are a danger to the community. The next hearing that you'll attend in court is the pretrial. Now, sometimes the courts will have the pretrial and the arraignment on the same day. Other courts will have them on separate days. So depending on the court, you may be there for 2 hearings on one day, or you may be showing up on 2 separate days. Now, at the pretrial, that's your attorney's first opportunity to speak with the prosecutor. The prosecutor is the attorney opposing you. He works for the state or the city, and he brought the charges against you. Now, in their conversation, they're going to discuss things like, can this case be dismissed? Should the charge have been a lesser charge? Is there a deal available? Or is this a case that the two of you just simply disagree on, and you will just have to take the case to trial? Now, if the case is dismissed, then the case stops right there. The court loses jurisdiction over you. Any bond conditions are terminated, and any bond that you posted would be returned. If you take a plea, then the case would go to sentencing. Depending on the charge, sentencing can result in anything from jail to fines to restrictions on your license, community service, alcohol and drug testing, educational courses, whether they be for drugs, substance abuse, theft prevention, anything of that nature. Those are all common things that could happen at a sentencing. If you take the case to trial, your attorney is going to talk to you about 2 types of trials. One is a trial by the judge, where he decides everything, and the other is a trial by a jury, where the jury is going to decide the facts of the case and the judge is going to decide the legal issues. Now, most of the time, I recommend a jury trial, but in some instances, and with some judges, a bench trial is also a good way to go. You're going to have to consult with your lawyer, and based on the facts of the case and where you are and which judge you're in front of, they'll help you make the decision. With a few minor exceptions, there are really just 2 outcomes at a trial: guilty or not guilty. If you are found guilty, then you would go to sentencing, as previously mentioned, and if found not guilty, then it's similar as if the case were dismissed. Your bond is returned, bond conditions are terminated, and you go on your way. The court loses jurisdiction. In a felony matter, the criminal procedure is very similar. You will still go to district court and be arraigned, and you'll have a pre-exam conference, which is pretty much the same thing as a pre-trial. The next thing that will happen after that is a preliminary exam. At a preliminary exam, the prosecuting attorney will have to prove that a crime was probably committed and that you probably committed it. If the prosecutor meets their burden, then your case is bound over to the circuit court for arraignment. If the prosecutor doesn't meet their burden, then the judge could rule that the facts only support a misdemeanor that should stay in district court, or the case can be dismissed entirely. Arraignment at circuit court and the procedure thereafter is just like the arraignment I've already discussed in district court. You proceed to a pretrial, and you would ultimately resolve the case with either a deal, a plea, a dismissal, or you go to trial. Thanks for watching my video blog on Michigan court procedures. If you have any questions, feel free to contact my law firm at 734-453-7806. And if you've been charged with a crime, contact us immediately. We fight for our clients, and we get results.